Good day. It is the CrimeTalk Weekend Update. That's right, a compilation of all of the top stories throughout the week, conveniently located in one location. I hope you enjoy it. Have a wonderful weekend, and we'll see you next time on CrimeTalk. Richard Allen, the man charged with the 2017 Delphi murders of Abby Williams and Libby German, remains in custody at an undisclosed state facility. Now, the Indiana Department of Corrections released a new mugshot of Allen, who has been moved to a state facility for his safety. He was previously transferred from the Carroll County Jail to the White County Jail. Now, as soon as the Indiana State Police announced that Allen's arrest and revealed that the murder charges filed against him during a news conference on October 31st, the case is marked by a little bit of turmoil. Overwhelmed, Carroll County Circuit Court Judge Benjamin Diner recused himself from the proceedings, citing concerns about his personal safety and the tidal wave of media and public inquiries about the Delphi case. After the judge's recusal, the Indiana Supreme Court assigned the case to Allen's Superior Judge Fran Gull. Allen's probable cause affidavit still remained sealed, and the court had set November 22nd for hearing to determine if those records would remain out of the public eye. Now, Allen faces 2 counts of felony murder, a charge that can be filed against the defendant who may not have actually killed somebody, but participated in the events leading up to the death. Now, for those who don't know, Abby Williams and Libby German disappeared on February 13th, 2017, while walking on the Delphi Trail. Their bodies were found a day later on February 14th, and while police have released some key evidence in the case, including an audio recording of the man saying "down the hill" and a pair of sketches, and details about Allen's arrest are minimal. Now, according to court records, Allen's trial is tentatively scheduled for March 20th of 2023. And that's probably not going to happen. But utilizing phrases such as bloodlust, toxic, and imminent danger, the judge ordered that the Carroll County Sheriff to hand over custody to Richard Allen to the Indiana Department of Corrections for his own safety. The court stated in their order, the court finds that the defendant is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. The court wrote that in the order that was posted in the morning, referring to a toxic and harmful insistence on public information about Mr. Allen's case. The public's lust for information before it exists is extremely dangerous to all public servants administering this action, and they do not feel safe and are not protected. The same day the court made this order, the judge recused himself from the case. Now, Allen was arrested on October 26th, and the Indiana State Police post in Lafayette 1 week after investigators searched his home outside Delphi, Indiana, for evidence linking him to the murders. 2 days later, Allen's initial hearing was held behind closed doors without public notice. I think that's a big no-no. And when the troopers at the Indiana State Police put handcuffs on Mr. Allen, told him he was under arrest for the killing of those 2 girls, abducted on the Monon High Bridge east of Delphi, well, the clock started ticking on his constitutional rights. Obviously, one of them is presumed innocent. Now, after the initial hearing 2 days later, without the presence of a lawyer, he's moved from the Carroll County Jail to the White County Jail to the Indiana Department of Corrections for his own safety, which is apparently almost unheard of. And the sealing of the probable cause affidavit detailing the case against him could give Allen and his counsel an opening to challenge the charges against him. All of that in conjunction or combination is extremely rare, and there's a constitutional presumption to open access to public access to the courts. Now, while the focus this past week has been on efforts by the media to get the charging information under the Indiana Open Records Act, Mr. Allen has a more pressing constitutional right to be fully briefed on the allegations that led to his arrest as set under court rules. Now, under these rules, it's also pretty much called for that those cases get unsealed when the warrant is served and the defendant is arrested. The post-arrest sealing of the information to a defendant who is already in custody is really rare. But as a result of his detention without notifying him of the nature of the charges, or having an attorney, or even being able to argue that this could have been prevented from getting an attorney from being moved around, it's a problem. In addition, he has a right to see what evidence is being used against him. and him saying he wants to have an attorney see that. Well, guess what? There could be motions made to dismiss as well as motions to suppress. We'll have to wait and see. I'm telling you, we've talked about this before on Crime Talk. It is a problem when the courts don't think that the public can handle it or somehow going to prejudice a case. It's not. There's remedies for that. It's called change of venue. It can be done. So, real big problem here. So as things progress, now we have the Superior Court Judge Fran Gull, and she was assigned by the Indiana Supreme Court, which is normal when a judge recuses himself. The Supreme Court will usually decide what's going to happen. So because of the concerns about the media and the public safety, that's why this new judge was appointed. Now, Allen told Judge Diener at the initial hearing that he intended to hire an attorney. Faces a November 17th deadline to inform the court. Now, the first reaction that any defendant's going to have is, I want to hire an attorney. But given the fact that he's been moved, he can't access the phones, how's he going to be able to take care of this? He just can't go out and retain one. Then also, does he have the funds necessary to retain private counsel? Is he going to have to use the public defender? Well, if they're bouncing him around, they're not going to have an opportunity to talk with him either. So this case has been set for November 22nd. That was set before the judge recused himself to decide whether they're going to unseal the probable cause affidavit, which is absolutely, completely fair for them to do. And Allen has an absolute right to see the charges against him. And the affidavit for the arrest warrant is going to provide an outline of the evidence that they have against him as well. Like I said, he has a right to know the nature of the charges. He has a right to know what evidence is going to be presented or the basis for holding him, his liberty being taken from him. Now, Allen and the state also face a 30-day deadline to file a motion to seek a change of venue if either side feels that they cannot receive a fair trial or they potentially feel that the court would be biased against them as it relates to the county in which it is going to be held in. Given the fact that the court has recused themselves, it would seem pretty obvious that they're probably not going to hold the trial in the county in which it's currently being charged. Just makes common sense. The other thing is the trial date, okay? The speedy trial clock has begun counting. Now, it wouldn't surprise me if that early trial date in March doesn't proceed. There's no way that the defense is going to be able to prepare for this case in that short amount of time, assuming Mr. Allen can get an attorney, whether he's going to use the public defender, but they're going to need to determine where the case is going, where should it be tried, and what are the natures of the charges, any possible defenses, experts, very unlikely. And with the 2 counts of felony murder, which have aggravators, include kidnapping, as well as wrongs against minors, prosecutors could consider on whether to pursue the death penalty for the murders of Abby and Libby. Now, the felony murder charge can also be lodged against the defendant who may not have actually committed the killing, but participated in the events that led up to the deaths of the young ladies. It would not surprise me that, like I said, this trial date is not going to go. They're going to need time to prepare, particularly if the state's preparing this case for some period of time against Mr. Allen, although you got to wonder why it took so long, but the prosecutor, should be ready to go, even though they say the investigation is ongoing. Makes me kind of think it's going to be a Lori Vallow type of situation, or could be the type of situation where the prosecutor really isn't ready. It could be an advantage to Mr. Allen, but the reality of it is the prosecution needs to get ready, and this information needs to be released. There's nothing in there that's going to be so shocking to everybody that we can't handle it, that it's going to affect the trial. Mr. Allen's going to be given the presumption of innocence. If jurors are honest in their response to questions in voir dire, if they don't think they can be fair and impartial, guess what? Then they just simply are not going to participate. It's that simple.
So the reason why the Carroll County judge disqualified himself from this case isn't exactly known to the public. That information must be given to the newly appointed special judge, but the public, well, we may never find out exactly why the judge did it. It is common for a judge to recuse themselves if, in fact, there is an actual conflict, okay? If a judge, for example, in the federal courts has a financial interest in any case, they must disqualify themselves. If for some reason there is a close relationship between the judge and maybe one of the prosecutors or defense attorney in the case, that has to be disclosed, and it could be a basis for disqualification. But for a judge to disqualify himself, he has to say, I just don't think that I can be fair and impartial. I've never heard of a judge say, I don't want to take this case because it's going to be high profile. I could be put under scrutiny. I've never had a judge do that. And most judges are quite candid with it. There was a judge that I did many, many trials in front of. I actually represented a relative of theirs. And every time we would start a trial, the judge would call the prosecutor up and say, I just wanted to be known that, Mr. Reich may have represented so-and-so, blah, blah, blah. And everyone's like, okay, fine. That's great. Because I don't think the judge gave me any special treatment. If anything, he probably went the other way to make sure it didn't look like that he was being giving me any favors whatsoever, which he never did. He was a great judge. He called balls and strikes. Wasn't swaying to one side or the other. So now we have Judge Fran Gull from Allen County, and she is taking over the Delphi murder case in regards to the death of Abby Williams and Libby German. And it's unlikely that she is going to disqualify herself, because she appears as though under the Code of Judicial Conduct, there's no good reason for her to do that. Like I said, high profile, high scrutiny. Maybe if the judge knows a witness, but they don't think they can be fair and impartial, that's very odd. So like I said, a lot of times it comes down to, hey, I worked with this person at a law firm. I have a financial connection in this case, or I'm just biased. But if the judge is saying, hey, I'm biased, which he kind of did when he said, this lust for information that the judge said, he really kind of said, I just don't want any part of this circus that's coming this way. Like I said, it is up to the judge if you have to disqualify yourself, but only if it's warranted. You have a duty to preside when disqualification isn't warranted. For example, if a judge looks at a situation saying, boy, this is a political hot case and I'm going to catch a lot of flack for this, I don't want to sit in this case, that's not appropriate. Okay, judges are there to supposedly make the hard decisions, to do what they have to do. So now the ball is in the court for the Honorable Francis C. Gull. So what do we know about Francis C. Gull? And I just didn't even notice. Francis C. Gull. Well, she served as a judge in the Allen Superior Court since January of 1997, and she was first elected judge in 1996, and she's been reelected for that position 4 times. For more than 20 years, Judge Gull has served apparently as an administrative judge of Superior Court's Criminal Division, overseeing the day-to-day operations of 6 criminal courts, including the misdemeanor and traffic and felony courts. So what that tells me is that she is the presiding judge over the criminal judges in that particular county. Usually that goes to a senior judge, which she would be in this case because she's been on the bench for 25 years. And so, like I said, during that 25 years, judges apparently has gained statewide and national recognition in areas including jury management, restorative justice, and the use of technology in the courts. She's been honored several times for her contribution to the criminal justice system, including she received the 2015 G. Thomas Munsterman Award for Jury Innovation, presented by the National Center for State Courts. And since June of 2002, Judge Gull has supervised Allen County's nationally renowned drug court program, the program which promotes recovery for addiction and restoration of families torn apart by substance abuse. And then in 2020, the program was approaching nearly 1,000 graduates, making it among one of the most successful and impactful in the country. Now, Judge Gull, we know that she received her bachelor's degree in political science from St. Joseph's College in 1980, and she received her law degree, a Juris Doctor, from the Valparaiso University School of Law in 1983. And I have to say, I've never heard of this law school, but it is in Indiana, and it looks reputable. Anyway, it's an accredited law school. After receiving her law degree, Judge Gull began her career in the Allen Superior Court, serving as a law clerk in the Family and Criminal Divisions in 1983 and 1984. And then prior to becoming a judge from 1987 to 1996, Judge Gull served as the Allen County Prosecutor's Office, where she was a chief deputy prosecutor, a role in which she served from 1990 until her election to the bench. In the prosecution's office, she also served as the chief counsel, criminal division, deputy prosecuting attorney. She was in the sex crimes unit and the section chief of the felony division. In the prosecutor's office, Judge Gull prosecuted hundreds of offenders. In the sex crimes unit, she was responsible for cases of sexual assault, women and children, and later as section chief in the major felonies division. Her trial schedule expanded to include robbery, burglary, arson, battery, and other serious felony offenses. As the chief counsel and then chief deputy, she was responsible for the prosecution of all homicides, high-profile felony cases, arson investigations, and cases involving political figures. So it sounds like she has all the qualifications and of a good judge, and it seems like she's going to be ready to go. Now, what I said the other day was that there are no coincidences in criminal law, okay? And is it a coincidence that an Indiana judge dropped multiple charges against a man accused of talking to one of the slain Delphi girls on the day she was murdered? Remember Keegan Kline? We've talked about him a couple of times over the last week or so because he'd been linked to the case of Libby German and Abby Williams since his arrest back in 2020. Now, for those unfamiliar, the girls were murdered on Valentine's Day of 2017 in Delphi, Indiana, after taking a hiking trip on an abandoned Monon High Bridge. Now, Kline allegedly confessed to investigators back in 2020 that he used a fake profile and photos to allure underage girls via a social media app. He also admitted that he spoke with Libby on both Instagram and Snapchat just before her death. An Indiana judge dismissed counts against Kline days after police arrested Richard Allen on the Delphi case. Now, Allen has been charged with obviously the 2 counts of murder in connection with the girl's death, and prosecutors filed a motion last week asking for some of Kline's charges to be dropped, which included the 30 counts of sexual exploitation involving a child. Another request has been reportedly filed to downgrade the remaining charges as well. The prosecutor apparently said there is insufficient evidence to prove said counts beyond a reasonable doubt. Technically, they can't do it. And yes, prosecutors have an ethical obligation to dismiss the counts that they don't think that they can ethically obtain a conviction upon. But the timing is very coincidental, isn't it? Coincidence, coincidence, coincidence. So according to the court records, the circuit court judge, Timothy Spar, dropped many of the 30 charges, and officials have not said whether the drop charges are in connection with the Allen matter. Although, as we talked about the other day, there's a transcript out there where Kline was being interviewed by the police, and it tries to intimate that he knew the killer involved in this particular case. Now, in that transcript of the police interview with Kline back in 2020, it showed that he failed a polygraph examination when he said that he didn't know who killed the girls. That same polygraph, the transcript shows, revealed that Kline was being untruthful when he said he stopped messaging with Libby in his catfish persona. A guy by the name of Anthony Schatz was the screen name that he was using, who was apparently, this persona that he was a teen actor and a model just 2 weeks before the murders. And when investigators told Kline they believed that he spoke with Libby during her overnight stay with Abby before they took their fatal hike, he initially denied it. And yet, the messages continued on Libby's phone, although the messages with her were deleted from Kline's. So investigators appear to begin to wonder if someone stepped into Kline's place for the last 2 weeks. So during the time frame where this grooming would have been built up to meeting, one of the detectives tells Kline's in the transcripts, it's wiped from your phone. So now it all starts to stack up. The complexity of your Anthony Schatz persona, the cars, the influence of Lamborghinis, Ferraris. It's not you. It's not your idea. You and I both know it's not your idea. The complexity of it, okay? It's not you. So Kline held fast through that, and he never copped to knowing anything. But the transcript noted he was temporarily released from jail in custody of the Indiana State Police back in August, the very day that officers began a 5-week search of the Wabash River. Remember what I said, there are no coincidences, ladies and gentlemen. Now, meanwhile, as we talked about before, Mr. Allen has pled not guilty and is reportedly exercising his constitutional rights to remain silent We always encourage people to exercise their constitutional rights. And hey, never punish anybody for doing that, because you never know when you may have to do that as well. Now, during the press conference last week, the police said that the probable cause existed and other evidence in this case existed for an arrest to be made, but we're going to keep everything secret. Listen to our previous videos when we talk about the concern there. We're going to talk about that more tonight, my concern as to why it is. It just always seems like these smaller jurisdictions want to keep everything a secret so as not to offend somebody, because everybody knows everybody. Guess what? Nobody cares. It's just another case. It's a homicide case. Just because it has more publicity on it doesn't mean that the rules get to be changed. So we have to wait until November 22nd to determine whether the unsealing will take place as it relates to the probable cause affidavit. And hopefully we'll see what facts or what piece of evidence they have to hold Mr. Allen in custody. And next on the docket, the Lori Vallow matter. The hearing has been sealed before it's even been held. Now, normally what would have been taking place on the Lori Vallow matter is that the judge would hold a hearing back in chambers, and then he would do some sort of perfunctory order saying, hey, I'm going to seal it. But then Lori Hellis, who we've had on this show, said, hey, Judge, you're not following the law. You need to follow these particular steps to do so. And well, there's a hearing set today. It'll probably take place by the time this video gets up on to YouTube. But the reality of it is we are not going to know, because the court stated in this order signed today, but back on October 31st, the court scheduled a hearing for November 9th. And in accordance with the Idaho Criminal Administrative Rule 32, the hearing will be referencing information that is expressly exempt from public disclosure. Accordingly, the court determines that the closure of the hearing and the sealing of the record is necessary in order to protect individual privacy rights and interests and to preserve the party's right to a fair trial. And such action is no broader than necessary to protect the fundamental rights. All right, let me tell you what's going to happen without even being there, okay? We all know Lori Vallow went back to the Idaho Department of Health, where they're going to reevaluate her for competency. The Idaho Department, the evaluators are going to prepare a report, and they're going to give it to the judge. A copy is going to be provided to the defense, and the prosecution will get a copy as well. And it's going to come down to whether they determine that she is competent or not. Now, I agree that people's medical information is, what's the word I'm looking for? Yes, there's privacy interest to it. But I've never been in a hearing where competency has been discussed where it's not discussed in an open courtroom. Sure, you're not going to get into, oh, we're on this particular drug. It's simply a question of, is there enough information to determine whether the person is competent to proceed or not? And if not, then the proceedings need to be stayed. If there's a hearing, I've never done a hearing in the judge's chambers. I've never done a sealed hearing as it relates to competency. It's done all the time. Only in Lori Vallow's case is it apparently so secretive and so protective of privacy rights. You think we're not going to know whether she's competent or not, Judge? Are you kidding me? I just don't get it. We've talked about this. When things are done in secret, people lose confidence, okay? People have lost confidence. I certainly know I am losing confidence in what is taking place in Idaho. Maybe if I knew what the heck was going on, like I could find out in just about any other criminal case, I would have some confidence. But at this point, color me skeptical. Color me skeptical indeed. Like many Americans, we got a dog during the pandemic, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied. So we created a high quality CBD product that absorbs faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, Enter code WINNIE and receive 15% off your first order. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. All right, we're back. More hearings in the Lori Vallow-Daybell matter. As we told you the day before and yesterday, that's right, there were hearings scheduled in the Lori Vallow matter yesterday in regards to her competency. No word that she showed up in court yesterday, because normally we can see video of the defendants coming and going into the courthouses there. She wasn't there. What does that normally mean? It means a report was probably sent, and the report said, not competent to proceed. We're going to need a little more time to fix her up. But of course, no one's entitled to know any of that information exactly, because why would the court want the truth to get out there? Otherwise, you can just have people speculate, pontificate as to what they think is going on. By God, we don't want the truth. There's nothing private or personal about whether somebody's competent or not. Sure, the information, I've done lots of hearings over the years where competency's been an issue. Sure, we don't distribute the report to everybody and say, Judge, we got the report. Everybody agrees the person's competent or not competent. Judge, they found that the person was competent, so we want a hearing before the court. I mean, what kind of great secret has been revealed there? Zero, zip, nada, nilch. Apparently in Idaho, though, they really protect one's privacy. So like I said, I'm going on a limb here, but I think nothing's changed in her situation. And then there was also the hearing today as it relates to Daybell in regards to the severance issue. Now, we've previously brought you a video regarding the motion to continue. And in that motion to continue, it was very specific as to the reasons why the court should grant a continuance so that the counsel can be up to speed and be effective assistance of counsel, but also the fact why they wanted severance. And the motion for the severance was that, well, it's the same thing that I've been saying since this case originally started, was that Daybell needs to blame Lori Vallow and her now deceased brother, Alex Cox. They're the ones that did it. I had no idea they were doing it. I had no idea until we got arrested. That's how bad it was. Or maybe if I knew something afterwards, I was scared because, listen, this lady's dangerous. Everyone around her winds up dead, right? So we previously discussed that motion for severance that Mr. Pryor had filed on behalf of Daybell. It's pretty simple. Inconsistent theory of defenses. Lori Vallow did it. Her brother did it. Giving me a separate trial. There's going to be lots of information that is going to be totally against Lori Vallow. It would be unfair for me to present that evidence against her. So just generally when it comes to severance, when two or more defendants are jointly indicted or in the same information for any offense and there is material evidence not relating to reputation, which is admissible against one or some of them, which is not admissible against all of them if they are tried separately, and which is prejudicial to those against whom it is not admissible, those against whom such evidence is admissible shall be tried separately. The word shall. That doesn't mean discretionary. It means mandatory. Shall be tried separately upon motion of any of those against whom the evidence is not admissible. In all other cases, defendants jointly prosecuted shall be tried separately or jointly in the discretion of the court. So this section is mandatory when it appears that the defendant would be prejudiced on a joint trial by the admission of evidence which would not be admissible against him, but which would be competent evidence as against the co-defendant. A defendant is entitled to severance of trial as a matter of right if there is evidence that is admissible against one, but not all of the parties, and if the evidence is prejudicial to the defendant against whom the evidence is not admissible. And the Supreme Court has stated that this generally means that the trial court must determine whether the admitted evidence was so inherently prejudicial that the jury could not have limited it to its proper purpose. When does this normally come into play? Well, when, say, for example, a defendant has given a statement or confessed that is obviously admissible against that particular defendant, and then you have another co-defendant saying, I didn't do it. Well, it's prejudicial against the co-defendant who didn't give any statements to have the statement of a co-defendant, a co-conspirator coming in against them. Well, Supreme Court says you can't do that. Separate trials, whether you like it or not. Like I said, it gets a little trickier if there's a conspiracy alleged, as there is here in the case against Lori Vallow and Chad Daybell. And if I were the attorney, I would be asking for what they refer to as an 801 D2E proffer. That's right. Under the rules of evidence, under 801 D2E, the government has to be able to show that a conspiracy existed, and not just think that there's a conspiracy. They actually have to show how they're going to establish it. And then statements made in furtherance of the conspiracy come in, not as hearsay, but as admissions. It's non-hearsay because they're made in furtherance of the conspiracy. But the defense should be asking, saying, give me this proffer so I can know what statements are going to be made, who's going to be offering them into court, under what theory they're coming in, and then the court can decide whether it's in furtherance of the conspiracy or not. Not everything is in furtherance of a conspiracy. So it gets very, very tricky indeed. In this particular case, I think there is enough evidence for inconsistent theories of defenses. The court should sever the cases. Why would this not be severed, in my humble opinion, is because the judge listens to the DA and they keep crying foul that it's too expensive to do this trial twice and it's inconvenience to everybody, etc., blah, 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 blah. Go try the case, okay? I know the prosecution wants to do one trial, and it's always about the money, how expensive it is to do two trials. Put on your big prosecutor pants and go do two trials if you have to. This case should be severed, or guess what? It is another appellate issue if Chad Daybell and Lori Vallow are found guilty. All the appellate courts have to find is it should have been severed. You have to go do it again, 3-5 years later down the road. Why risk it? Just give them their fair trial and then convict them. Next on the docket, is Alec Murdaugh going to testify at his friend's trial? Now that's friendship, right? So Alec Murdaugh has apparently planned on invoking his Fifth Amendment right against self-incrimination if called to testify in the ongoing federal trial of his former personal banker and friend, Russell Laffitte. Now, Murdaugh's attorney, Jim Griffin, recently sent a letter to the court outlining the conditions under which his client would appear as a witness for Mr. Laffitte. However, Mr. Griffin declined to confirm what Mr. Murdaugh wanted to testify to at trial. He also did not give any indication of what Mr. Murdaugh might say in the event that he was actually called to the stand. But he did say that his client, Mr. Murdaugh, is willing to testify, assuming the federal government agreed to the specific conditions outlined in his letter to the court. Those conditions, apparently limited use immunity. So anything that he says could not be used against him in a case against him in the future. Yeah, that's not going to happen. Obviously, with the approval of the U.S. District Court judge, that would have to take place. And, of course, the prosecutors would have to do that. Or if there was some sort of agreement to limit the scope of his testimony as to what the scope of his communications were with Mr. Russell Laffitte. Yeah, that's not going to happen, okay? No federal prosecutor is going to give immunity of any kind to Alec Murdaugh in any way whatsoever to come and testify and help the defendant in the case. Yeah, that's not going to happen. And the government doesn't give somebody immunity unless they know exactly what they're going to say. And it has to help the government, not the defense. Remember, this is not about justice. This is not about making sure all the truth comes out. This is about winning at this point. I know prosecutors have that ethical obligation to seek justice, not convictions. Oh yeah, we're so far beyond that. All right. So, so the jurors in the trial of Mr. Laffitte should not expect to see Mr. Murdaugh at all. And if Mr. Murdaugh were to be called to the stand, it would be done outside the presence of the jurors so that they could not see him invoke his right not to testify in front of the jury, because that would be too prejudicial. Just saying, ladies and gentlemen. I can't believe an attorney would agree to anything like that unless you get immunity, which the government is not going to do.